Okay, hi everybody. Again, I hope you had a chance to look at the intro video. So this will be what we'll call episode 1 after the introduction. First of all, I would like to introduce Lainey the Conlaw dog. Since I have to do these videos, this is always going to be a risk. So, she's now finished barking. She's a 6.5-year-old German Shepherd, again named Lainey, who still behaves like she's 6.5 months old. She has that much energy. So, so your Conlaw 1 course comes with a mascot. So I hope you'll consider that a bonus. But I've just decided to go with the flow here and make her part of the show. So let's talk constitutional law a little bit here. I want to, in this video, address a few things that make constitutional law challenging, and I don't mean to scare anybody off. In fact, I hope to do the opposite, right? I hope to kind of allay any anxieties or fears that people are coming at this with already. It's very common for students in Conlaw 1 to come into the first class, right, when we're meeting in class, but we'll again have, you know, our meetings online. A little bit, you know, nervous about the reading that's already been done. So I want to talk about a few things to keep in mind. Number one, the cases that you read in most of your courses, you know, you open your torts book or your contracts book, right, something like that, criminal law, whatever the case may be. Generally speaking, when you look through those case books, what you see there are cases from all kinds of courts from all over the country, right? You have cases from state appellate courts, right, whether it be a state court of appeals or a state Supreme Court. You have cases from United States District Courts, right, which is a trial court in the federal system. You have cases, some cases maybe from the U.S. Supreme Court, but you know, in most of your case books, those are going to be few and far between. Now, when you open your Chopper book, right, the 13th edition, that's your case book for Conlaw 1, you'll notice as you flip through the book that just about every case that's cited in there, right, not every case, but just certainly all of the major cases, are cases from the United States Supreme Court, right, which is the highest court, obviously, in the land. Now, you might ask, well, so what does that have to do with the quality of, right, of the writing or the reading or being nervous about the subject matter? Okay, think about that. Let me tell you that when I was, my first job out of law school was clerking for the Michigan Court of Appeals, right, which is the intermediate appellate court in obviously the state of Michigan. So the job of an appellate court is to review, right, for error below, right, in the trial court. Legal error, right. Appellate courts really don't look at factual matters very much. You know, as a general rule, they don't do that. They leave that to trial courts to be the finder of fact. Appellate courts are looking for legal error below. Now, when you look at these layers of courts, right, so the trial court is reviewable by, let's just take where I practiced, right, the Michigan trial court, which in Michigan was called district courts and among other things, but the trial court hears case, right, they know, a trial judge knows that he or she is reviewable by the Michigan Court of Appeals, right. The Michigan Court of Appeals, on the other hand, knows, or I should say in turn knows, that its decision is going to be reviewable, right, if the Michigan Supreme Court wants to hear it. If the Michigan Supreme Court hears a case, and if they happen to be hearing, deciding a case that revolves around a federal question, we'll talk more about that later, even their decision, right, on a federal question would be reviewable by the U.S. Supreme Court. So, again, you see these layers of courts. So I can tell you from experience, when I worked for the Michigan Court of Appeals, that the job of a clerk, because part of what we did was, right, we wrote draft opinions. We certainly didn't write the final opinion in the case unless it was adopted by the judges. But there's a department in the Michigan Court of Appeals, at least when I worked there, right, that drafted reports for the judges and also draft opinions, suggested opinions. Now, those opinions, when they come out of whether you're a trial court clerk or an appellate court clerk, right, that's below the U.S. Supreme Court, the opinions that you write should be what judges call reversal proof to the extent possible. In other words, you are going to very carefully discuss, right, the issues that are presented in the case. You're essentially going to IRAC them, right? IRAC. Very carefully. You're going to address every issue raised, right? Not just the dispositive ones, to make sure that you've dotted all your I's and crossed all your T's. That means that when you read a case, say from a U.S. District Court, or a U.S. Circuit Court, which is the Federal Court of Appeals, right? Or the Michigan Court of Appeals, or the Alabama Court of Appeals, whatever the case may be, you're probably reading an opinion that was carefully drafted and meant to be understood by somebody who's higher in the food chain, right? The judicial food chain, right? Now think about this as it applies to the U.S. Supreme Court. Who reviews a U.S. Supreme Court decision on anything? Think about that for a minute. Answer in your head. If the answer in your head was nobody or maybe God, right, that's it. The U.S. Supreme Court writes opinions that are not reviewable. That means they're not necessarily meant to be understood, right? I mean, it'd be nice, right, if we understood what the Supreme Court was saying. But we'll see as we go through the material. Sometimes a Supreme Court opinion reads like this, right? Yesterday the rule was X, today the rule is Y. You want to know why? You want to know our reasoning? Here's our reasoning because we said so, right? Because they're the Supreme Court. That's all they have to say. So, number one, I appreciate that, and anybody who teaches constitutional law appreciates that we're asking you to read opinions from a court. The opinion may make sense or it may not. Our job as lawyers and law students and law professors is to extract legal principles from these cases, right, that can be applied to future fact patterns. So we will work on that, but again, I don't want you to think that you're alone when you read cases, right, throughout the term and think, I don't really, this isn't really IRAC, I'm not sure where this is going. Number two, you gotta be mindful that you're reading very old cases, right, and in many cases, right, from the 1800s, early 1900s, we start in 1803. So you're going to be looking at what I call ancient verbiage, right, that can be a little bit thick, right, to kind of wade through. Make sure you have a dictionary handy, right, when you're going through these cases, and, but obviously, when we meet and in these videos, we're going to hope to make sure we come out of this having all these principles in plain language. You do have to know the magic words, right? I call them magic words. A friend of mine who used to teach constitutional law in Michigan used to tell his classes, you have to use the magic words, and what's so magic about these words is that when you use these words, points magically appear, right, on an exam. So we're going to memorize the magic words, but we're going to do a deep dive into what they mean and come out with a plain language understanding of all of the principles that are in play here. Finally, and I'll do a separate video about this because it's going to take a little time. Finally, you're going to be dealing with rules out of these constitutional cases, right, from the Supreme Court, that they're not necessarily what you're used to from other courses, right? If you're looking for whether somebody committed a tort, usually there are elements of a tort. Even negligence has elements, right? If you're looking for whether somebody committed a crime, usually there are elements of a crime. In constitutional law, courts are, especially the Supreme Court, right, which sets the rules, is very likely in many cases to create rules that don't fit into elements in a nice, neat way, right? They're not necessarily just categorical or elemental rules. The Supreme Court also uses a lot of balancing tests, right, which are very flexible. It uses a lot of tests that are based on factors rather than elements. We'll talk about what that means, but factors are things that are considered rather than outcome determinative. And it does occasionally employ something called a means-ends test, right, which you're going to be very familiar with by the time you're done with constitutional law. Now, so I don't know, so I think some students think that's bad news, right? So in constitutional law, we have elements, we have factors, we have categorical tests, we have means-ends tests, we have balancing tests. That's a lot. That's, by the way, the Quinnipiac Law Review article that I asked you to read is about that. So that's a lot to digest. The good news is rules are rules. All rules are if-then propositions, right? If something happens, then there's a certain result. If something exists, then there's a certain consequence, right? That's the way rules work. Again, more about that later. But I wanted to start with recognizing those three challenges and making sure that you're comfortable with that. don't be alarmed, right? If you read a case and you think, okay, number one, they weren't very clear about that. It doesn't look like they were writing this opinion for a higher court, because a higher court wouldn't know what they're saying. That's pretty common. So don't worry about that. Make sure you have a dictionary handy, and we'll wade through the old-fashioned language, and be ready when you're on the lookout when you're reading these cases for different kinds of tests that are not just elements or categories. So that's enough for this video. The next one will be about those different types of tests. There's all kinds of things, that I could cover in video 1 and 2. It's hard to know what to put in 1 and what to put in 2, but we'll just do it this way. So stay safe and stay tuned. I'll have another video up soon.